introduce the concept of ownership to us as a legal concept, as something that has to do with policy and all of that. But I can't find it here. So let the presenters of seminar paper 1 get it across to me for purpose of allocating mark for them for CA. These ones, they didn't even indicate their group. Right. The people who wrote on right of occupancy, myth or substance, I have their own too.
That's group 3, sir.
Okay, I have that one too here. Then I have yes, ownership of natural resources.
That's group 5,
they
sir.
too didn't indicate their group number. Group what? Group what is
group
this?
5, sir.
Group 5. Okay. I have that one too, yeah. Okay, group 4 was on, I have group 4 here too. They were those who presented on the use of the concept of
property risks and titles, sale of goods.
Yes, the use of the concept of property risk and title sale of goods. I have that one too. So all of these are on possession and ownership. Let me see. Yes, still under possession and ownership, the way I grouped it, specifically under possession, I have the seminar paper on justice and finder's right in the law of torts.
Yeah, that's good.
You may have treated it as tort, but the way I couched the topic, I was examining possessory rights. And it's a common adage that possession is 9/10 of the law. And that some of the things that show that are the right of a finder and the right of, in the law of tort, and the topic of prescription, where you give a person by merely being in possession of something for a long period of time, you give him a prescriptive title. He's able to exclude even the owner. Okay? And some of the time you give him, he has not been in possession for a long time, but has been misled by either words or conduct or whatever of the true owner. And you say that you want to use equitable principle of estoppel against the owner. All these are meant to look at the ingredient of possession. And when in jurisprudential term we say possession is 9/10 of the law, or possession is 9/10 of ownership, what aspect of the laws are there to buttress that generalization? That's what we have tried to do. But so you will see that we did more topics on ownership possession. So I want to tell you here now that we will not be doing justice to the exam if we don't set 3 questions from that aspect. Wow. I don't know the questions, but I know I'm going to set 3 questions from that aspect. But let me tell you straight away that I will do in such a way that if you really master any 3 seminar presentation in that subject area, you should be able to answer at least 2 questions. So I'm going to, if you look at the way I set my questions in this area, if I want to examine possession, I can tell you to discuss finder's rights. Okay? I can tell you to discuss finder's rights or the doctrine of estoppel or the concept of prescription. That is those statutory provisions that will say that if you have waited for too long to assert your right over a res, most often land, that you lose the right. Okay? So I treat those ones as relating to possession, emphasizing not only that the law protects mere possession, but also that some of the time the law would confer on a mere possessor a right, even against the true owner. Okay? So if you read all that have been presented on finder's rights, just a limitation or prescription. Limitation and prescription, they mean the same thing. When you talk about title by prescription, you are saying that long possession is the basis of conferring on someone a title. Okay? Unfortunately, I didn't see their own paper here. I know that a paper was presented to us on that. When you talk about finder's rights, you are talking about situations where the person in possession is admittedly not the owner. He's not even asserting ownership. But under some conditions, as between him and others, is able to assert ownership by virtue of that mere possession. Okay? So, if I want to ask you a question on how the law protects possession, I may just tell you to discuss finder's rights, prescription, just 30, and all of that. Okay? As I'm talking to you, I have not set your questions, but that looks like something I would do. So, and in order to give you latitude to master one area very well, I might say you discuss it in relation to this or this. So that's why what I mean by saying, if you really master on each topic, if you really master one area very well, you won't come out of my exam and say you didn't find something to write. Then the other broad area that I normally discuss is the area of demonstrating that ownership is not a factual concept, is a legal policy concept. and whether as to what can be owned or as to the constituent of the bundle of rights that you call ownership, the law is always ahead or different from the facts. Okay? For example, we talk of land. You cannot be talking of ownership of land without recourse to the legal system that you are talking of. This is where you may be told to discuss something like a right of occupancy. A right of occupancy as prescribed in the Land Use Act is a demonstration of the limit to absolutism in the ownership concept. So that when Austin gave a definition, he gave a very individualistic definition, indefinite in terms of user, unlimited in terms of control, whatever, and all of those things that he said. Well, that is the ordinary meaning. That is the ordinary meaning. What we have seen is that there is nothing absolutely unlimited. Okay? Legal systems will prescribe one limitation or the other. And it is either you want to look for another name for what legal system has done, legal systems have done, or you want to accept that the exact meaning and function of ownership vary from legal system to legal system. So when we want to examine this type of concept, we can tell you to take a natural resource, for example. We can tell you to take the limited liability company, where the issue is whether ownership includes control or not. So the paper of managerial revolution, you might read and say, what is the relevance of this to our syllabus? The relevance of it is that if you are really including as an element of ownership, you are including control, then, and you are saying that both factually and logically, that the owners of a company then will be the capitalists, those who contribute resources together to get 100% of his shares. Then it is either that ownership does not include control in its attribute, or that the idea of what ownership means in relation to the joint stock company has changed over time. Because as the people who coined the idea of managerial revolution have demonstrated very clearly, control has moved away. Control has moved away from shareholders. Control is now in the hand of managers, especially if it is a joint stock company with a public limited liability company. So what do we say about ownership with regard to the operation of limited liability companies? Do we still continue to say that such enterprise are owned? If so, by who? If you include ownership, if you include control as one of the elements of ownership, then you will not be 100% correct to say that, either to say that the enterprise of the joint stock company is owned, or that it is owned by the capitalists. Okay? So we can also examine the concept of natural resource. If we are talking about ownership as it relates to land, okay, as it relates to land and whatever is on land or under land, the idea you have is quick platato solo sedit, or the thought equivalent of it, the one that says that the man who is the plaintiff in a tort that is done under or over land is the owner of the soil. So we result that somebody, an airplane flies over your land and disturbs you, you have a right to sue because it is committing its nuisance territorially over your land. Okay? A person does something from his own land undernet the soil, it causes harm to yours. The third version of quick plantato solo said, I can't remember it now, Kujus, Exolium method, Kinika, and Inferos, that they used to teach us in those days in law of thought, will tell you that yes, because it is under the soil that you are deemed to have owned, to own, you are the one who has a right. But we have seen now that when it comes to natural resource, depending on the type of natural resource, some countries will not permit you to lay claim to whatever it is that is under nature soil. We will now have different mode of ownership. So you look at the paper on natural resource was a particularly fine paper. We talking about the theories and talking about the different concept of ownership in different countries. So that also goes to establish what we are saying, that don't look at ownership as a factual concept. Don't take any theory of it. Just accept that it is a policy concept, and as such, what it will mean will vary with time, and will vary with place, and will vary with legal systems. Okay? So all of these topics are just meant to just prove just one small thing, that there is no giving universal meaning for the concept of ownership. So just go and master. I've given you the broad categorization now, the possession topics. Master any one of them. Maybe you want to master finder's rights. You want to master prescription. You want to master, I think it's the same people that spoke about prescription and estuped inequity. Okay? So you want to master any of this or one or two of these to show, to demonstrate that the law, in fact, almost protects possession more than it protects ownership. And there are many a times when you have a conflict between the person asserting possession and the person asserting ownership. I say many a times, not all the time too. Because even when cases like Amako and Obiofina, we are talking about the possessor's right to assert trespass, they said it is against everyone except the person with a better title. Okay? But most of the time, whether the defendant has a better title or not will depend on the facts, will depend on a lot of argument and all of that. But it is often very easy to establish what you call dominion or possession. And so those group of papers, try and master one or two of them. The group of papers that gave you idea about the different meanings that the word ownership could have. Okay? Whether with respect to immovable res, that is land, or with respect to movable res, movable tangible res. That is like, as for example, sale of goods. The different meanings you could have, whether with regard to what can be owned and what is the meaning of ownership and what limitation, contrary to what Austin is talking about, the legal system will prescribe, will be another group. Okay? So I might decide to just tell you to talk to establish why you can't be talking about absolute ownership when you are talking about, you can't be talking about individual ownership or absolute ownership when you are talking about resource control. Okay? And things like that. So that's another group of paper. But I will not limit you in such a way that, I've read everything. It's only the paper on managerial evolution or the paper on resource control that I didn't, natural resource that I didn't read. See, I'm not able to answer any question. That will not happen. So if you make up your mind now that, look, the lecturer has given me an idea. He has given me some seminars that are on possession that I may not master all of them, but if I master one very well, I will be able to answer a question on possession. He has given me the seminars that are on the relationship between ownership as a concept and policy and policies of legal systems, different legal systems, okay, under which such topic as the nature of the right of occupancy. Why are we discussing right of occupancy in a jurisprudence class? Just to show you that over time, ownership of land has changed. What it means when you are said to, as an individual, to own land, it has changed. When we say meat or substance, we're trying to tell you that, can you really equate the right of occupancy with any of your own idea of proprietary rights over land? Is the right of occupancy exactly a lease? Is it exactly a license? Does it compare with your idea of fee simple in possession, or your idea of family ownership of land under customary law? And so, Omotola, God bless his memory, will say that the right of occupancy, that we make mistakes when we is looking at the right of occupancy by trying to insist that it must be anything that we knew before. So he says, look, the right of occupancy is sui generis. It's sui generis. It's probably a new concept altogether that you cannot say it's exactly this or that or those or anything that you knew before. Yet, it has to be something. It has to be something. That itself is a proof that ownership is a policy concept. So, I am sure of those two. And I'm sure that if you master your papers on ownership and possession, you will be able to come up with something. You'll be able to answer in that two classification, you'll be able to answer one or two questions. Okay? I'm not sure of the third question I will ask in that area now. I'm not sure now. Okay? Some seminar papers might just be lucky. I might just look at one seminar paper that is general in nature and use the discourse to be the third question. Okay? I am looking at that seminar paper 1. Is a general introduction. But let's see how it goes. So the other parts, the theories, you can't escape the theory. I've listened to Crank Captain try to persuade me against theory. We didn't say much and all of that. Okay? We did the theories for thought and contract. Master one of them. I won't bring a question that will limit you to thought or to contract. But if you have mastered one of them, okay, there's no way you get to the exam hall and be eating your Bible. So, Odimeni, isn't it? Hello, I'm giving you 4 now.
Yes, Prof. Yes,
Yes,
Prof.
bro.
Yes, Prof. Thank you, Prof.
Then,
Yeah, thank you, sir.
yes, we discuss which one is a mental state out of intention, recklessness, and negligence. And which one is suitable? Which one is suitable for as a basis of responsibility in criminal law or civil law? So you must first understand the difference between the three concepts. Remember I told you that in ordinary language, recklessness is the biggest problem you have, because ordinary language might present recklessness as if it is gross negligence. But legal language will present recklessness as if it is intention. Okay? So recklessness is a mental state. It is not that the doer or omitter did not foresee the consequence. It's only slightly different from the person who intended it, because the person who intended it actually desires it. But the reckless person knew that that is going to be, that is the probability of what he's doing. But he will not caution himself, he will not do anything to prevent it. Okay? But negligence is truly negligence in the sense that you acted as an unreasonable person. You didn't put yourself to have that state of mind for what you call a mercy. I remember the people who presented paper to us on that area. They went into the details of menswear, the distinction between menswear as a common, as our criminal legislations are saying, and all of that. The bottom line is that you are negligent when you did not foresee what a reasonable man would have foreseen. And so the law does not punish you for your mental state in negligence. The law punishes you for not even having a mental state at all. Okay? For not having a mental state in circumstances where you ought to have. And that is why we will often say that liability, as far as criminal law is concerned, is strict whenever it's strict or absolute, whenever your state of mind, your mental element does not determine your culpability or otherwise. And I think we've spoken about all of that in the presentation. If you are not able to gather what we want to say from the seminar papers, just take Cocoa and Nice and look at his explanation of what are strict liability crimes and all of that. And do also address your mind to between criminal law and civil law, which is much more appropriate to use negligence as a basis of liability. How often does criminal law use negligence? And is there anything that you can see, any threat that you can see running through those occasions when a person might be made criminally responsible without having a mental element. Okay? So 5 is complete, isn't it? Why don't you give me the 6th question? Let me have an idea. Leave it to me. Let me decide what it will be. Okay? Sincerely, in the course of the last in the course of the last few years, we have never had this large class in jurisprudence. So I've never had problems telling you what seminar papers to read. Jurisprudence seminars are usually maximum 7, 8 seminar papers. And so if you want to be fair in rewarding everybody, you can easily pick 4 or 5 and spare the remaining 3. Okay? So, but here I'm in a situation where I can't use seminar to say, go and read seminar 1. So what I can do is to group together seminars that are teaching the same things. And I guess that apart from intentional recklessness and negligence, the other thing we treated very well are the type of the expanded topic of fault, absolute, strict, vicarious, corporate liability. If you master any of those ones, I think I will make them the 6th question. So look at the seminar papers that discuss those ones. For example, the seminar paper that discuss corporate criminal liability, the seminar paper that discuss the distinction between fault, strict, and absolute liability, whether from perspective of criminal or civil law. Okay? And the one that discuss the issue of, I think that was the last thing. Okay, there was also motive and malice. Motive and malice and all
Yes,
of
sir.
that.
Motive and malice in thoughts and
Just, I want to assure
in
you now
criminal
that
law.
master any 2 of those group of seminars, you will find something to say. Master any 2. If you think that, oh, you like the discussion on motive and malice, whether in criminal or civil law, master it. You will find something to say. If you think that it is corporate criminal liability that you have looked at, all of those papers are not even here anyway, for me to remember anything we said in the show of them. But if it is that one that you want to emphasize, the thing about those ones is that mastering the seminars alone, you'll be able to convince an examiner if you really master what was presented. So for me, I think jurisprudence has always been a sweet exam, and it will remain so. To remain so, there's no reason why anybody should fail. Okay? And there's no reason why concentrating on the seminar presentation and our discussion, you should not do well. There's no reason. Okay? You can look at past questions to see my pattern of examining. Okay? To see that if out of the 16 seminar papers presented, you sat through at least 7 or 8 and read and understood what was said there, you won't come out of the exam hall gnashing your teeth or saying that, this exam is hard. The exam will not be hard. Exam is the least of my problem. Do you understand?
Yes,
Yes,
Prof.
sir. Yes,
Yes,
sir.
Prof.
Yes,
But
sir.
let me
Thank you,
ask
sir.
you a question. Is there any particular seminar presentation that you want used for the exam that I've not talked about? I've told you now that in the latter part, we talk about recklessness, intention, and negligence. In civil and criminal law, we talked about fault, absolute, and strict liability. Fault, absolute, strict, vicarious types of liabilities along that line. And I've said that we also talk about corporate criminal liability. And I said that we talk about motive and malice. Okay? Whether as an offense or as a defense. Okay? Whether an offense simply means the conduct of the person is ordinarily not blameworthy, but his motive makes it so. Okay? As a defense means the conduct of a person is blameworthy, but because his motive for doing so is appealing, you therefore want to say that that should obliterate uh, his liability. Or malice, on the other hand, I remember the presenters gave some very technical meaning for malice, but I have always understood malice to be bad motive. Okay? I've always understood it to be bad motive. So, with the bad motive of a person for exercising a right which he has, will it take away that is right? Okay? But there are some wrongs that only become wrong because of the malice, like defamation, malicious prosecution, and all of that. When that happens, there are elements of the thought, and therefore they become the crucial element you have to establish, either to find guilt or to find civil liability. Okay? So those are all the things we have covered towards the third part of our seminar presentations. And I can assure you that if you master, say, any two seminar areas, maybe intention, recklessness, and negligence, you say, okay, I also want to concentrate on motive and malice. You will be able to answer at least two questions. That is in the third part. So, summary, the ownership topics, you've seen our direction, just to demonstrate that there is no fixed meaning for the concept of ownership. Whether you are looking at it from the perspective of what can be owned, or you are looking at it from the perspective of what aggregate of rights, what bundle of rights constitute ownership, that it is a function of which legal system are you talking about? Which time are you talking about? And that is what jurisprudence mean when they talk about it as policy matter. Okay? What we have done is to look at different subject areas just to demonstrate that same point. Okay? So whether you are looking at it from the perspective of how right before our nose, the meaning of ownership of land changed, or how different countries treat natural resource, sometimes not the same policy or theory will apply to different type of natural resource. Okay? There will be a difference between those natural resources that do not stay put in one place. Okay? And those that will remain fixed. Okay? There's a difference between legal systems and their perspective. Okay? So the idea whether a person is the owner of oil and minerals will require another question. Where? Under what theory? Under which legal system? So that establishes what we are saying. The ownership is a very, very policy-inclined concept. And you cannot say this is what it will always mean, irrespective of under which legal system or irrespective of which race you are talking about. Okay? Then the possession topics. The law protects possession, sometimes to the detriment of the owner. Okay? And sometimes as between two non-owners. The law takes possession to be a determinant of who keeps the item. Okay? I said there's a third question that I will look at because I will ask 3 questions from those areas. Okay? And I said the 2 theories, contract and tort, master them. Master at least one very well, because there will be a question which will give you the option to choose what theory you want to discuss. So then I said the later third of the semester, we discussed liabilities generally in criminal and civil law. We talk about when you say fault, it tends to be associated with mental element. Which one is a mental element? Is it intention? Is it recklessness? Is it negligence? Okay? And from perspective of either criminal or civil law or both, which one should remain the basis of fault liability? Then we broadly now look at the whole idea of liability, moving away from fault liability, which we have now discussed. We move that sometimes you are not really at fault, but nevertheless, the law holds you responsible. So you should be able to distinguish between fault and strict liability, or the one we call absolute liability. You should also know vicarious liability. Okay. Then you should know corporate liability, especially in criminal law. Why and how can a company be punished for a crime when it has no hand, when it has no mind to form an intention? Okay? Then finally, we have done motive and malice. Okay? Motive and malice. How do they operate? To find either defense or liability in criminal and civil law. Any question before I go? Please let me have your seminar papers. So those
Yes,
that
sir.
have not announced that I've seen their papers here, let me have them, because unlike what we did in the first semester, I'm going to assess them myself and allocate mark. Okay? Then the class governor, you know that presentation will carry 5 marks.
Yes, sir.
So let me know who are those who were not present during their group presentation. It's not fair. It will not be fair. It will not be fair for them to score the same mark for presentation.
Okay, sir.
Even if we know that we can begin to say this person did not participate in. Was it in this class that we had a person whose group ostracized him because he didn't participate?
Yes, sir. Group 8.
Okay. Group 8, what is the seminar paper of Group 8?
Group 8 seminar paper is theoretical basis for thoughts.
Okay, theoretical basis for thought. So, okay. Will the group members kindly agree to amend to include his name so that I don't have a problem remembering anybody's name?
Sir, they claim that they have amended their seminar paper and they have submitted it. So I don't know if their paper is among the ones that you have. His name
No,
is
I don't.
Adefowa. His name has been included. But you
That's
said they
what
should
I want.
amend. They
That's
should
what I
amend their
want.
seminar papers.
I've not seen it yet. I
Okay,
don't have
sir.
any paper on any of the subject theories. I
Okay,
don't
sir. I'll
have.
notify them.
If they have not done, let them do. I'm sure I will get the other ones.
We've submitted it, sir, in the department.
Which department?
Today?
Is it with the
Jurisprudence.
secretary?
Yes,
Today?
I submitted to Mr. Dapo, sir.
Today?
No, on Tuesday, since Tuesday last week, sir.
But it was yesterday I told them to bring to me everything they have now, and yours is not included. Maybe that didn't put it in my cubicle in the department.
We were
Maybe,
the first group that submitted.
or maybe that has it somewhere else. Or yes, maybe he has it somewhere else. Don't worry, I will collect it. But you have already included the man's name there, Abi?
Yes, sir.
Okay.
Yeah. Hello, sir.
Yes?
Yeah, I'm Mr. Adefora Dediji, sir. I have
Yes.
contributed academically. I wrote my part and I submitted, which has been included.
No problem, no problem.
Then I have another question, sir.
Yes?
You said that if we have any question, we should come up with the question. Sir,
Yes?
first of all, I want to thank you for the fatherly way you were able to teach us about this course and the way you have been able to guide us in such a way that we'll become very competent in what we are doing. Secondly, you have also given us an area of concentration that we should go and master. But you have not been able to mention area, what you are looking for. What are the things and things, the elements you are looking for in our answer script so that we can help us to elevate our scores?
My
Thank
friend,
you, sir.
it's a jurisprudence class. You limit the student when you begin to confine them. That is the way I understand jurisprudence. Do you understand? You can answer
Yes, sir. Yeah.
in the summary form 500 words. And if you have the time for an Ll.M class where you have 3 hours to answer 4 questions, you can write, say, 2,000 words. So,
Thank you, sir.
in assessing you, the lecturer will have to bear in mind the number of words that you have time to write. Whether upon reading what you have said in summary form, you have said what he wants, what the question requires. And based on that, you see, jurisprudence is different from many other subject areas because you cannot have those strict marking scheme that we usually have. I want this point, I want that point, what you want is an intelligent discussion. Do you understand? An intelligent discussion of the questions that have been given. Okay? And likely, if you familiarize yourself with the relevant seminar papers, that's why I've told you now that in order for you to really, really familiarize yourself with seminar papers, you might decide to, okay, I want to concentrate on the papers on negligence, recklessness, and intention. Let me take it together with, say, corporate criminal liability, so that you will be able to present in an excellent manner anything you are asked from those areas. We won't ask you you know that jurisprudence will not ask you problem questions. We will not ask you problem questions. Okay? For LLB, we ask largely theoretical question. What did Austin say? What is the idea of natural law school and all of that? But for master's class, we are doing applied jurisprudence. We want to look deeper into what you already know, but you have never bothered yourself about presenting it in a theoretical jurisprudential manner before. So for me, look, if you are writing and making sense, even you yourself will know. Do you understand?
Yes, Prof.
Yes,
Master
sir.
the technical papers and master them from the broad categorization I have done. And will most likely be decently. But that's what we did to cover the ground. Okay? And if I'm not going to be there, my colleague will also have the seminar papers so that she can guide herself with what was discussed in class, so that she won't have a different idea of what you should say. Okay?
Okay, sir. Yes, sir.
The
Thank you,
question
Prof.
I wanted you to ask me is, I asked you is, do you have any particular seminar paper? I said, Prof, please help us examine this paper. I won't want to hear it from the presenters of the paper, those who didn't present it. Say, okay, this particular paper, this particular seminar paper, oh, we enjoyed it. I know that most of the time, you people don't need until exam is 1-2 weeks away. So you may not be able to say you enjoy one particular seminar paper, except those who presented it themselves. So I know that the question I'm asking, I won't get any answer. So let us all just go. And I will set my questions in the pattern I have stated.
Thank you, Prof.
Thank you, sir.
Thank you, Prof.
Thank
Yeah,
you,
thank you,
Prof.
sir. Thank you, sir. Yeah.
Thank you, Prof.
Thank you, Prof.
Thank you, sir.
Okay, see you on exam day, if I come.
God bless you,
Or whether I
Prof.
come,
Thank
I
you,
don't come.
sir.
Thank you, sir.
Thank you,
We
Prof.
will write
Thank you very much, sir.
Thank you, Prof.
Thank you, sir.
Okay.
Ah.